Assalamualaikum and good morning to the panels. Hi, my name is Zulaika Adrana binti Effendi. I will be presenting on my legal research paper, where this is a comparative legal analysis in regards to the economic impact of online defamation, and there will be a comparison between Malaysia and the United Kingdom. So this will be the content of my research paper, starting from the abstract, moving on to the introduction and the overview to the topic of this paper, problem statement, research question, and also research objective, the literature review, the methodology, which is the method used in this area of study, analysis and finding of this research paper, and lastly, the conclusion. So first of all, we will look into the overview of this paper itself, where the aim of this paper is to investigate the relationship in the online setting when speech is no longer qualified as free, and it escalates into defamation. So the purpose of this research is to study the efficacy of existing laws in Malaysia in governing such a danger to society and how it significantly affects corporate reputation. So this study will provide an insight into the applicability of the Malaysian Defamation Act 1957 in terms of the publication rule and the protection available to the online intermediaries. So the continued advancements and emergence of various forms of internet-based publication, like for example, social media networks, weblogs, and online forums in the 21st century has radically altered the channels of communication, because most individuals see this as a beneficial accomplishment and praise everyone's nerve to publish online and find essential data. So along with these perks comes the growing harm, which cause those who post false business reviews, personal abuse, and altered photos and videos. So the foundation of this research methodology is based on qualitative research, which semi-structured interview were conducted with 4 relevant interviewees or the respondent to study their views on the economic impact of online defamation. So the research question of this paper is firstly whether internet defamation gives significant impact to the corporate reputation as well as to the society. So the second research question discuss on whether freedom of expression grants the right to harm a person in cyberspace by making false statement. And lastly is what are the ideal alternatives and approaches that the Malaysian government need to put in place in order to change the law, or also known as a law reform. So the interview findings have supported that existing law in Malaysia are severally enough in providing protection to the online intermediaries. So since Malaysia is the Commonwealth country, a comparative analysis with the position in the United Kingdom will be assessed, and the comparative analysis will permit this study to navigate an assortment of elective approaches that can be utilized as a structure for law change in Malaysia. So this research will aid in the comprehension of the enormous impact of internet defamation on corporate entities as well as to the economy. It is fair to say that the situation in Malaysia and the United Kingdom are relatively similar, where both governments emphasize the importance of knowing the knowledge as the part of online intermediaries before holding them accountable for defamation. So next, will be a brief introduction of the on what does online defamation actually means and how it has been in Malaysia. So globally, people appear to be unaware of the risks shared on other social media by negative or derogatory posts, and the internet has made it difficult to control defamation. So these networking sites have made it feasible for internet consumers to instantly publicize any wellspring of information or news to the overall population, where it is in contrast with the conventional advertising, where influence are constrained by geological limits and jurisdiction. So the capacity of these online platforms to connect to the network has attracted a large number of users to spread false and misleading materials in the cyberspace. So under Article 10 of our Federal Constitution, everyone has the right to freedom of speech. There is no doubt that this right is important and must be protected for obvious reasons. However, it must be balanced against the right of a person to not be defamed. So this is the primary purpose of defamation law, which is essentially a balancing of two competing rights, which is the first one is the right to freedom of speech and the right to reputation. So, with the advent of technology, breaking news can reach to anyone with an internet connection in a matter of seconds. At the click of a share button, a blogger or maybe a social media user's post can easily go viral on the internet and reach thousands of people in a short period of time. So, this is especially in the case when since we it is this is especially when the case is sensational or catchy headlines are used to quickly grab the attention of the online readers. So the longer these posts remain online, the greater the damage. When one is faced with such a situation, the usual course of action that is often taken starts with the issuance of a letter of demand, followed by legal proceeding. However, there will be circumstances where the content of the publication are so damaging that it cannot be allowed to remain published, and therefore urgent action is required to restrain such publication. Online defamation is one of the types of cybercrime, while it refers to the series of events that involve repeated interaction with the target. So the aspect is fulfilled with respect to wrongfulness if the credibility of an individual has been damaged and an objective examination is used to assess whether the good name of a person has actually been tarnished. So, once the release of defamatory content has been confirmed, the courts conclude that the intention to harm. Online defamation is characterized by its fast propagation speed, higher level of attention, and low cost of law, which makes defamation crime easier to implement and more difficult to reduce. This is meaning that, in other words, defamation is generally considered to be an intentional infringement of someone's right to his good name or deliberate publication of words concerning corporate reputation. Thus, this paper aimed to study the effectiveness of Malaysia's existing law in providing protection to such a threat to society, particularly in corporate reputation, given that the cases of online defamation are reportedly increasing. So, moving on to the problem statement of this paper. Firstly, we are going to discuss on the issue when competing business defame each other on the internet. So a business competitor could use any number of tactics to harm the business reputation of another company. This can range from making up negative reviews, making negative statements about the company's practice, or even making personal attacks on a professional or business owner and their family. So, unfortunately, the internet provides some level of protection for many people to engage in an activity they would never do face to face. So, while individuals are often victims of this type of unlawful behavior, businesses can be victims as well. With one click, defamatory information can be spread to thousands of users in seconds, tarnishing a business reputation indefinitely. So next is the tension between free expression and defamation. So defamation law are not prohibited by human right instrument. On the contrary, by recognizing the rights to reputation and privacy, they implicitly support them. However, if not carefully applied, the defamation laws can have a chilling effect on speech, limiting both those who express themselves and those who have the right to receive information, opinion, and ideas. Furthermore, if speakers are subject to the laws of any country in which their remarks can be accessed, local defamation laws can pose a global threat to free expression. So, as for the third one, the complexity of online defamatory material must be considered, and any restriction must be stated clearly in laws to be adequate and vital. It is sometimes difficult or impossible to identify the author of the articles, as the internet users nowadays do not expose or reveal their real identity on the internet where the publisher will not disclose any of their identity due to confidentiality. Therefore, the common practice is to issue a letter of demand to the publisher for removal of defamatory article and request the publisher to notify or inform the author to remove the article. So majority of publishers are willing to remove the whole defamatory article or particularly the defamatory parts after conducting an examination through the article by making reference to letter of demand in order to avoid litigation. So lastly, there is an urgent need to amend the Malaysian Defamation Act 1957. Regardless of the differences between the UK and the Malaysia, online defamatory content is typically available for an indefinite period of time and can be easily repeated or republished in the cyber world. Nonetheless, internet users in the United Kingdom are no longer subject to indefinite liability because the Defamation Act 2013 has introduced a single publication rule that allows their liability to expire 1 year after the statement was first published. So this reflects the Defamation Act 2013 adoption of the single publication rule. On the contrary, the multiple publication rule still apply in Malaysia, and as such, any online defamatory content in web-based publication is gravely exposed to unlimited liability. The situation in Malaysia is, however, has slightly changed with the serious implication of the newly inserted Section 114A of the Malaysian Law of Evidence 1950. It is submitted that the use of codes of practice, as has been practiced in the UK, may be considered so as to provide protection to the online intermediaries. So a good code of practice should be very clear and include a procedure for dispute resolution. It is suggested that an online intermediary which follow the code of practice ought to be exempted from liability and should not be exposed to the general law. So moving on to the research question and the research objective of this paper. So the first research question is whether internet defamation gives significant impact to the corporate reputation and the society. So the next research question is whether freedom of expression grants the right to harm a person in cyberspace by making false statement. And lastly, what are the ideal alternative and approaches that the Malaysian government need to put in place to change the law as a law reform? So as for the research objective, this paper aimed to study the significant impact of online defamation to the corporate reputation and economy. And next is to examine how a person's right to free speech might harm someone in cyberspace by making false statement, and to analyze the most suitable approach and method that can be implemented as for the law reform by the Malaysian government. So as for the literature review, we will be discussing on three areas because there will be a comparison between Malaysia and the United Kingdom. And the third slide of literature review will focus more on the impact of online defamation to the corporate entities. So as for the first literature review, we will be focusing on the implementation of defamation laws in Malaysia. So in Malaysia, the concept of libel law cannot be addressed in isolation without making a cross-reference to the law of defamation. So the law of defamation in Malaysia is primarily based on the English common law principle, except insofar that it has been modified by the Malaysian Defamation Act 1957. So according to Talib 2010, internet defamation generally involves the online publication of a false statement or fact that is harmful for one's reputation. There may be some exception of additional element of showing malice where the plaintiff is a public figure. So under common law, defamation refers to the publication of untrue statement of fact which reflect on a person's reputation and tends to lower him in the estimation of right-thinking members of society generally, or tends to make them shun or avoid him. So next, according to Wong 2007, although the media is act as a powerful channel for conveying and disseminating information in a democratic environment, it is undeniable fact that the media at times are peculiarly vulnerable to error or confusing the public interest with their own interests. Hence, it is vital to note that in the process of conveying and disseminating the information, there is a need for the media to exercise their self-regulation and to be a socially responsible vehicle of communication, since the right to publish is not absolute. So in essence and in truth, the various law that we have today were never intended to kill the creativity of journalists and media people, but to sanction and bring to book the writers who carry poison pens and those so-called writers who love to lace their writing with innuendos, defamation, and sedition that may lead to instability and lawlessness. So next, according to Maria 2015, in order to prove a defamatory statement on the basis that it is libelous, the plaintiff must establish the element of distort, which the first one is the word must be defamatory, the word must refer to the plaintiff, and the word must have been published. So looking at the first element, it will suffice to note that what is required on the part of plaintiff is to establish that the statement or the words that form the subject matter of his complaint is defamatory. As a general rule, this requirement is satisfied if there is a harm to reputation. As to the second element, the plaintiff must show that the statement or the words were published is concerning to him. In other words, the statement must refer to him. It will be no defense that the plaintiff is not referred to by name if he would be capable of being identified and being the reasonable person. So regarding to the last element, for libel to be actionable, it must be communicated to a third party. For example, some person or other than the plaintiff. Therefore, if the printed materials are not seen by any third parties and only the plaintiff sees them, publication will not arise. So lastly, according to Show It 2012, though it is not possible to make reference to all section of the Defamation Act 1957, it could still be argued that the Act protects both private and public figures in Malaysia from being the victim of irresponsible journalism or the media from damaging their reputation. Meaning that, in other words, the law of defamation seeks to protect a person's dignity and honor. This, although the law recognizes that the damage to a person's reputation cannot be undone, the law seeks to console and to put right of what was wrong. Apart from the Defamation Act 1957 and the Penal Code, reference must be made to the recent amendment of Section 114A of the Evidence Act 1957. So the amendment was passed by Parliament with little debate in 2012. This section provides that presumption of fact in publication, and it stated that any owner, administrator, host, editor, subscriber, or network or website, or any owner of a computer or mobile device is presumed to have published or republished its content. So, moving on to the next slide, this paper attempts to compare the laws and the policies that are used throughout countries in the world to make a comparison with Malaysia's law and policies. In doing so, we are able to differentiate the strategies that are used in other countries in preventing online defamation. So it can be seen that the act of online defamation is not a bizarre occurrence in the region of Southeast Asia. However, in developed countries such as United Kingdom, where internet users in the UK are no longer exposed to indeterminate liability as the Defamation Act 2013 has introduced single publication rule, which renders their liability to expire after 1 year of the statement was first published. So the law of defamation in the UK is governed by the Defamation Act 2013, where in this statute, however, do not provide any explicit definition of what is meant by defamatory. So on the other hand, in Malaysia, the law which governs defamation is the Malaysian Defamation Act 1957. So this act is in pari materia with the English Defamation Act 1952 and governs civil defamation, while Section 499 and 500 of the Malaysian Penal Code deal with criminal libel. So similar to the UK Defamation Act 2013 Acts, where the statute provide no single definition of what defamation is. So this resulted in the courts in the country closely following the law in the UK. Okay, so the next slide is a literature review that will focus more on the United Kingdom. So according to Rogers 2017, it has been generally accepted since then that defamation refers to the publication of a statement which reflects on a person's reputation and tends to lower him in the estimation of right-thinking numbers of society. So with the convergence of telecommunication, broadcasting and information technology industries, and the rapid development of numerous forms of internet, based publication, which is the social networking sites like Facebook, Twitter, and many others, it is becoming more and more difficult to differentiate between the two. So, as opposed by Arnold 2012, the new Defamation Act 2013 has then inserted an additional prerequisite under Section 1, Subsection 1, which requires the claimant to prove the publication of the alleged defamatory statement has caused or it is likely to cause a serious harm to his reputation before a defamation action can be initiated. So Section 1, Subsection 2 of the Defamation Act 2013 provide that for the purpose of this section, harm to the reputation of a body that trades for profit is not serious harm unless it has caused or it is likely to cause the body serious financial loss. It is argued that the requirement of serious harm has raised the bar for bringing a claim in the UK, making it more difficult to commence defamation proceeding as it. So the incorporation of the single publication rule into the Defamation Act 2013 to replace the problematic multiple publication rule finally brought the enduring concern to an end. Nevertheless, the single publication rule was initially subjected to numerous criticism as it was claimed that the rule was unsatisfactorily drafted. So Michael 2010 argued that Section 8, Subsection 1(3) of the Defamation Act 2013 stipulates that the first publication of the defamatory material to the public triggers the 1 year limitation period within which the claimant must initiate his claim. This made the single publication rule very crucial for online content, in particular internet archive. So this rule can prevent an indefinite defamation action against the same person for publishing the same defamatory materials on the internet. And lastly, it has been suggested by Renault 2004 that court should treat online defamatory materials, especially posting in blogs, as a slander rather than libel, regardless of the conflicting argument on the application of the foresaid provisions. Blog entries have been said to have more in common with the spoken words than the newspaper publication. This is because they exist in Joe trust culture and are unlikely to be viewed as authoritative. So moving on to the third slide of the literature review that will focus on the impact of online defamation to the corporate entities. So according to Bill 2010, businesses are dependent on online reviews by customers for advertising and reputation, meaning that a negative review is not necessarily a defamatory, but if the review intentionally to make false claims against a business with the intent to harm it, the maker is subject to liability for defamation. So the impact and importance of online reviews is extremely important since a recent Harvard study shows that 1 star increase on Yelp leads to a 5 to 9% increase in the business revenue. So the authors of the Harvard study also conclude that the impact of consumer reviews depends on the existing reputation of a company or a product. Consumers' reviews are effective overall, but it will be ineffective when a product has a firmly established reputation. So Chester 2012 stated that negative reviews on consumer feedback websites or any social media platform can easily deter prospective customers from one business and direct them to one of their competitors. As a citizen, we must protect our right to express ourselves while remaining mindful of defamation, although there is nothing wrong with constructive criticism to improve a certain situation. So the internet defamation will cause monetary, emotional, and reputational harm. As opposed by Melinda 2016, the internet defamation can manifest in many forms, but the harmful result often include a measurable financial loss for an individual or a company in terms of revenue, profit, or expenses. An intangible loss may be hard to quantify, include brand, reputation, opportunity, cost, trust, and goodwill. A common misconception about defamation is that it strikes business engaging in activities that are unethical, fraudulent, or criminal. And lastly, according to Arifin 2008, although there is nothing wrong with constructive criticism to improve a certain situation, internet defamation will cause monetary and also reputational harm. The rise of Web 2.0 introduced a variety of social media platforms like Facebook, YouTube, Instagram, Twitter, which allow people to interact with each other. The ability for users to express their opinion and share their thoughts 24/7 has increased the chances for internet defamation to occur. So, given the level of cyber defamation present in many online forums and the difficulties this may present to users, it could be assumed that critical attention would be focused on the impact of such behavior on cyberspace. However, the bulk of research into online defamation appears to be directed at the macro level towards the potential impact of traditional, territorially based defamation law on the integrity of the internet as a robust marketplace of ideas rather than the damage it may inflict on individuals. So next, we will look into the method used to gather data in this area of study. So as for the philosophy, I use the interpretivism philosophy, where the interpretivist research philosophy is founded on the assumption that social reality and knowledge are subjective, molded by human experiences and social situation, meaning that the key of interpretivist research philosophy is the study of phenomena in their natural environment, for example, by conducting interviews and observation. I chose interpretivism because I believe that external social forces, as well as the fact, have an impact on this research paper. So next, I am conducting this research paper by utilizing qualitative approaches. Qualitative research is linked with the interpretivism research philosophy. Qualitative research is the process of acquiring and identifying non-numerical data, also known as descriptive data, such as interviews, in order to better understand the target audience experience and perspective on the certain topic that I want to obtain a comprehensive graph of this topic from informed and experienced people. And I believe that uh, primary data which gathered through interpretivism studies is generally reliable and honest, where there will be a high level of validity. So the method of data collection consists of primary method and secondary method. So the data that I wish to collect are relevant laws and statistics regarding online defamation in Malaysia. So subsequently, in-depth enforcement of such legislation. And I wish to hear personal opinion and suggestion regarding freedom of expression that escalates into defamation. So hence, a semi-structured interview was conducted where the respondents are the ones who directly active in this research field, such as criminal lawyers, NGO representative, as well as business owners or representative of any relevant corporation. So I've contacted the target respondent by sending emails to them as the first step in gathering data for this study. I managed to interview four respondents coming from different backgrounds, which is one of them is a business owner, a criminal lawyer, and also an advocate. So a set of questions were asked to the respondent in regard to the topic of this research. So example of the question is whether their company has been defamed before, and the second question is, do they think that internet defamation gives significant impact to the corporate reputation in society? And whether freedom of expression grants the right to harm a person in cyberspace by making false statements, etc. So during the interviews, I also designed a semi-structured question to allow for the emergence of new ideas and the posting of extra spontaneous inquiries. So as for the secondary method, I am also referring to the news and article from various websites and blogs so that I will have a clear view and better understanding in regard to this topic. So the crucial part of this research paper lays on the data analysis and findings. There will be three different findings for each of the research question. So in order to answer the research question, so the first finding is in regard to the first research question, which is whether internet defamation gives significant impact to the corporate reputation. So, based on the article opinion, or also known as a literature review, the author agrees that it would suffice to note that though it is not possible to make reference to all sections of the Defamation Act 1957, it could still be argued that the Act protect both private and public figure in Malaysia from being the victim of irresponsible journalism, which is the online publication, or the media from damaging their reputation. So, in other words, the law of defamation seeks to protect a person's dignity and honor. Thus, although the law recognizes that the damage to a person's reputation cannot be undone, the law seeks to console and to put right of what was wrong. To relate to this article, let's look at the finding from each respondent. Okay, so based on the findings from the semi-structured interview that has been conducted earlier, all of the respondents agree that online defamation has a substantial impact on both corporate and societal reputation. So Miss Wan Naimah, as the business owner, is in view that the tension between the freedom of speech and the right to protect one's reputation have long existed. So as a business owner, Ms. Wan Naima agreed that the internet is one of the factors that contributed to their company's downfall. She had received a lot of bad comments, especially on her YouTube channel, trying to bring down her company. So due to the rapid spread of false or defamatory statement online, a person's reputation can be damaged in a blink of an eye, as opposed by a criminal lawyer, Ms. Nur Shainas binti Azizur Rahman. Moving on to the next respondent, which is Mr. Sharizan Johan, also agrees that there is a significant impact on society as well as reputation of corporate entities, and this statement has been supported by Encik Khairul Anwar Shaharuddin, where according to him, someone's reputation might be tarnished due to the rapid spread of fake news through the online platform. So as for the overall findings and the answer of this research question, it can be concluded that all of the respondent is in view that the internet defamation truly gives significant impact to the corporate entities. Due to the rise of variety of social media platforms, these avail people from all walks of life to interact with each other, even also with anonymous strangers, and to express their personal view and thoughts, thereby highly increase the occurrence of internet defamation, where social media platforms are beneficial if positive and favorable content is shared. Conversely, such platforms are perilous when ratings, reviews, and verdicts are false, misleading, or derogatory. A company's brand's credibility and prestige can be immediately corroded by scam report published on the internet. So moving on to the second research question, which is where the freedom of expression grants the right to harm a person in cyberspace by making false statements. So as stated in the article, the media have not been immune from the crackdown on peaceful political commentary officials have denied. So the officials have denied license required under the Printing Presses and Publication Act, PPPA, to news outlet viewed as a critical of the government, and government agents have threatened to withdraw the printing license from presses that publish books and other material that the officials dislike. So the internet can serve as a double-edged sword because people now enjoy unprecedented access to information, and a powerful news means to exercise freedom of expression. So at the same time, abusive expression in the form of hate speech or information inciting violence and the spread of disinformation or propaganda. So according to Swaram, documentation, a number of ordinary citizens were charged with sedition in 2014 for statements that they have made on Facebook and other social media, while many more were subjected to investigation and arrest. So based on the findings from the semi-structured interview that has been conducted, majority of the respondents do not believe that freedom of expression include the right to injure others, particularly in online. So according to Miss Nur Shainas, she argues that we are guaranteed with freedom of expression or freedom to speech by our constitution, and it is a concept of the inherent human right to voice one's opinion publicly without fear of censorship or punishment. However, such freedom does not warrant a right to defame others, to save and to accept the statement made are true or non-derogatory, or fulfill the defenses of for defamation. So on the other hand, Mr. Khairul Anwar is in view that defamation is one of the exceptions to free speech, as freedom of expression allow the freedom to cause harm to others by making false statement, and this has been supported by the third respondent, which is Mr. Shahrizan Johan, where he disagreed that freedom of expression allows the freedom to cause harm to others by making false statement. As for overall findings and the answer to this research question, our constitution guarantees us freedom of expression, also known as freedom of speech, which is the concept of an inherent human right to express oneself openly without fear of censure or penalty. However, such liberty does not entail the right to slander others, whether the statement expressed are factual, non-derogatory, or satisfy the defamation defenses. So, at the same time, abusive expression in the form of hate speech or information inciting violence and the spread of disinformation or propaganda. So, here comes the third research question, which is what is the ideal alternative and approaches that the Malaysian government need to put in place in order to change the law as a law reform in regards to online defamation. So, as stated in the article, defamatory comments or remarks by online readers in relation to the original publication in the UK are treated as communication in transient form and thus a slander, while the Malaysian law does not distinguish between comments and original posting. So, there is clearly a pressing need for new amendments to be made to the Malaysian Defamation Act 1957. Publication of defamatory content on any types of internet-based publication shall be subjected to defamation law if such content fulfill all of the prescribed requirements. So in general, libel law will govern any defamatory material posted on web-based publication as they are considered to be publication in permanent form. So, on the other hand, defamatory comments or remarks by any online readers in relation to the original publication in the UK are treated as communication in transient form and thus a slander. So, based on the finding from the semi-structured interview that has been conducted, there is a few approaches suggested by the respondent. So the first recommendation is from Ms. Wan Naima, where she is in view that the current government should look at the comprehensive reform by studying the approaches of other countries. So according to Mr. Sharizan Johan, in any case, a committee should be set up to get feedback from the public and stakeholders on the issue of online falsehood. So the fourth respondent, Encik Khairul Anwar, argues that Malaysia already has enough law where law reform is not an ideal solution to be considered. According to Encik Khairul Anwar, a person's or a company's reputation is something subjective and intangible. Thus, it is important to look at the amount of damages to be awarded to the victim. So the overall finding of this research question is that the government, in reforming the Defamation Act, should take into account the rapid spread of rumors and also false statement nowadays on social media platform like Facebook and YouTube. Nevertheless, the insertion of Section 114A to the Malaysian Evidence Act 1950 renders all persons who act as an owner, host, editor or sub-editor or who facilitate to publish or republish any publication to be presumed as publisher under the law unless otherwise stated. So with this development, all bloggers or other operators of internet communication would be made as publisher and consequently liable for any online material posted on their website, which include any third-party content, thereby will eliminate the element of knowledge. This is somewhat perilous, and it would be premature to hold blog owners strictly liable for any defamatory entries by third party. So, for example, in the UK, due to the introduction of single publication rule by the Defamation Act 2013, if internet users are no longer exposed to indeterminate liability, because as I mentioned earlier, their liability would expire 1 year after the statement was first published. So, on the contrary, Malaysia still adopt the multiple publication rule, whereby any deemed publishers of any online defamatory content is gravely exposed to unlimited liability. And this could be supported by the recommendation of the second respondent, which is Ms. Nur Shainas, where despite the fact that Malaysian Defamation Act 1957 existed long before the internet was created, it is still applicable to govern the law on cyber defamation. Nonetheless, the complexity of online defamatory material must be taken into account, and any restriction must be clearly set out in laws, be based on compelling grounds, and be proportionate and necessary. Thus, it can be concluded that there is a pressing need for new amendments to be made to the Malaysian Defamation Act 1957, especially with regard to the publication rule and protection available to the online intermediaries, as well as what has been adopted in the United Kingdom. As such, the complexity of the internet defamatory material must be taken into account by the government, and any restriction, as I mentioned earlier, must be clearly set out in law. Although the law shall protect one that is being defamed, the current law in Malaysia would, however, backfire as the law in Malaysia allows for potential victim to sleep on their right. So moving on to the last part of this paper, which is the conclusion. So there are few limitations in completing this research paper. So the main limitation definitely would be the lack of time, which is the time constraint. Because the time given in completing this research paper is quite short, where I won't be able to have a deeper understanding on the issues of online defamation in Malaysia. And also, it is quite a hassle to find any latest data or statistic available for this topic, because most of the data is either up until 2017 until 2019, and there is no current data to be referred to. Other than that, I also facing few difficulties to reach the respondent for interview purpose due to the current situation where we are currently facing a pandemic. So I tried to send out emails to the respondent, and only few of them responded to my queries after a few days. As for the research paper, I want to make sure that it comes from different perspective, where I don't want to focus only on the eyes of law but also from the business entities. That's why my respondent is coming from different field, which is from business owners to advocate to criminal lawyers. And as for the concluding remarks, by looking at the Defamation Act 1957 and the Malaysian Penal Code above, it would suffice to note that we have these laws in order to protect a person's reputation, regardless of the notion of press freedom, since the right to publish by the media is not absolute. So, despite the differences between the position in the United Kingdom and the Malaysia, online defamatory content is normally accessible for an indefinite period of time and can be easily repeated or republished in the cyber world. So, nonetheless, internet users in the UK are no longer exposed to indeterminate liability, and on the contrary, the multiple publication rules still apply in Malaysia, and as such, any online defamatory content in web-based publication is gravely exposed to the unlimited liability pertaining to the liability of online intermediaries. So it can be said that the situation in the United Kingdom and the Malaysia is more similar, where both countries stress on the element of actual knowledge on part of the online intermediaries before holding them liable for the defamation. So the situation in Malaysia is, however, has slightly changed with the serious implication of the newly inserted Section 114A of the Malaysian Law of Evidence 1950. And the last part is the recommendation. So as for the recommendation, in the eyes of law, there is a pressing need for new amendments to be made in the Malaysian Defamation Act 1957, especially with regard to the publication rule and protection available to the online intermediaries, as what has been adopted in the United Kingdom. So on the other hand, as for the recommendation to the corporate entities, there are a few strategies which can be beneficial to someone in protecting themselves against a libel. So the first and most obvious is, of course, litigation. If they are successful in their case, they will likely be awarded monetary damages and often an injunction from the court ordering a person to remove the offending material and refrain from libeling them in the future. So the other major method for defending against libel is purchasing a reputation management service. Reputation management services often try to include threats or legal action against a publisher of libel as a part of their service for preventing their business from appearing in bad from appearing bad in search engine result. So this help to protect someone's business while avoiding the costly litigation that might come with a suit over libel. So therefore, that's all from me. Thank you.